Yes, technical difficulties have been omitted. Welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd. My co-host today is Pastor of the Way. Thursday, August 11th, 2022. And what we're going to discuss is a plethora of misquotes, miscitings, and just blatant, outright copying and pasting of case law that people believe to be true because it's in a legal vehicle somewhere, which means like a writ, affidavit, motion, whatever. And it's 100% totally inaccurate, has no validity, or it doesn't have any jurisdictional value where you're trying to file it in another jurisdiction, simply because it may be a state case and you're trying to file it on the federal level and that doesn't work. Or it could be a federal circuit in the Ninth Circuit and you're trying to file it in the Fifth Circuit and there's no Supreme Court case law to differentiate between the two. And they call that split circuit case law. So what I was trying to do is find a case just to show you how a case should be properly cited. Of course, I'm off that. Oh yeah, because I had to shut down those videos. Can you hear me?
Yes, sir.
Okay. Make sure I'm sharing. Why isn't that popping up?
Now, there is one thing about using case law from outside of the jurisdiction that a lot of people don't understand. You can use good case law from other jurisdictions as to prove a potential legal argument like legislative intent, but that's about it. You can't use it as authoritative.
Right. Yeah. You can only use it as to support your argument. Like, hey, over here, this is what Oklahoma and Mississippi and Florida and Georgia, this is how they looked at. I'm just going to use DWI as a field of law. This is how they handled a field sobriety test result, something like that, just to give you a hypothetical.
Yes.
Okay. So what we're looking at here is a case citing. And for this one, Higgins, which is the plaintiff, versus Boeing Company or Corporation, 526 Federal 2nd, 1004. Now, is the style of the case. This is the volume of the Federal Reporter, the second series. So they have a federal first series, federal second series, federal third series, and I doubt they're on the fourth, but possibly could be.
I've never seen a fourth.
Yeah.
Now the other thing is if someone asks you, give me the citation of the case, the 526 F2D 1004 is the citation. That's what they're asking for. They're not asking for the name of the case. The name of the case is Higgins versus Boeing and Boeing Company.
Right.
That's the name. The citation is always the number, letter, number combination.
Right. But the legal terminology would be, this is the style.
Yes.
That's the actual place where it is recorded. So I just used this one, just punched in some letters and numbers, and that's what I came up with. Now, this is the page in which this case begins. Now, if there was a specific quote or, specific quote in that particular case, it may be found, and there'd be this would be comma, and it would be 1008. So you would look at the case citing and you know, okay, this is where the case starts, but on page 1008 is exactly the quote that I'm looking for. Now, it's also going to have the jurisdiction, which would be the Second Circuit, 1975. That means this was adjudicated in the U.S. Court of Appeals for the Second Circuit in the year 1975. So this is what I'm talking about, split circuits or different jurisdictions, because you can read the holding in this case from the Second Circuit, but yet you can go find a additional holding in the Ninth Circuit that differs for this. It may be just the exact opposite of what this holding is. And so you're like, oh, okay. That's when you have a split circuit case, and that argument can be taken to the United States Supreme Court for the court to determine the split circuit and codify both of them together to determine which one is good law, which one is bad law. Or it can remand,
Yes.
whatever's being argued back down to lower court for another determination. Now, I believe it was this key. No, let me stop share because I had two cases that we looked at, or that you gave me, that are miscited that we want to look at. Now, when you see these sightings right here, there may be something in parentheses like en banc, which means the whole case. I mean, the whole court, all the justices or judges on that court heard the case, issued their opinion. I'm trying to think, it's been so long since I've done all this. Per curiam, that means that the court did it anonymously, or a judge or justice issued the opinion anonymously. So that's what those parentheses sightings after the case, that's what that means. So let me stop.
Don't you just love it when they do things like that and they don't want to say who they are?
Oh man, I wish I had $100 for all the opinions I had that were like that.
Look, it's just like I see a lot of these in the legal community of people over the many decades that have filed cases in court, and some win, some lose.
Right.
But the normal theme I see on Westlaw
Uh-huh.
is a bunch of them are not reported.
Right.
I said, huh, those are some interesting cases.
Right. This is the Rodriguez versus Donovan case that you're talking about. Let me pull it up on the share screen. Now, personally, I don't know jack shit about this case or the other one that you sent me. I don't even think I've ever opened them up, read them, or applied them to anything that I've. So,
Well, the only reason I know about them is in the early days, and this happens to most of us out there, when we are naive to how to study this stuff, how to read it, and we have our perspective teachers that we listen to,
right.
like Anna Von Reeds, David Strait, it don't matter.
Yeah.
You know what I'm saying? They will copy and paste a citation, claim it's the gospel, and it's actually a false citation. Okay. For example, let's see here. Let's see. I won't name the guy's name, but he put up a post in one of the groups I'm in. It says all codes, rules, regulations are for government authorities only, not human/creators in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking due process. And he cites Rodriguez versus Ray Donovan, U.S. Department of Labor, 769 F2D 1344, 1348, 1985. And that's just one of the citations that he put up. And I'm like, I've known about those for years. That's when I started discovering some of these supposed experts don't know what they claim they know.
No.
Because when you read the case, does it allude to it? Does it say it? The answer is no.
Right. So in this particular case, Rodriguez versus Donovan, when it is cited, this is the only thing that matters right here, because this is the holding. This is the argument that the court, and this is the Ninth Circuit, I believe. Yeah, Ninth Circuit Court of Appeals, which is in California, that area. This is all that matters. They decided this argument, and this is their holding. This is their opinion, and this gives you the statement of the whole opinion of the argument, where they go through this side's argument, that side's argument, their determination of applicable law, and then boom, this is our holding. So in this, the holding that allegations that the secretary, which is the Secretary of State, failed to give the plaintiff a hearing after the suspension of the plaintiff's benefits, and that there was a considerable delay in deciding the plaintiff's claim, stated a colorable due process claim. So the last sentence or last statement of this sentence, that's it right there. Deciding the plaintiff's claim stated a colorable due process claim. And this is writ of habeas corpus, I believe. Yeah, let me where's that? See, argued and submitted in 1984. And this is the panel, this circuit judges. This is a three judge panel. That's what it's called, panel hearing. Basically,
Yep.
you little synopsis, and then here's the facts. Blah 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 blah.
Now, I mean, you can do a control F on the case and just do search terms like the word lacking. On my Westlaw case I sent you, the word lacking didn't even appear in the case anywhere.
Right, and that's an easy way to
Okay.
do it. Very easy.
That is an easy way to check for citations, because if you find a case that is 120 pages, how long are you going to take to read that one?
Right.
You know what I'm saying? So you do a keyword search. The other one was the common law is the real law, the supreme law of the land. The code, rules, regulations, policy, and statutes are not the law. And they quote Self versus Ray. I can't tell you, that's the more popular of the two. But
Right.
when you go read Self versus Ray, it does not say that anywhere.
Yeah.
Now, is there a case out there that does say that codes are not law? Yes. But the judge goes and tells you why they are not law. And it has nothing esoteric, nothing to do with God, nothing to you being a sovereign, none of that stuff.
Right.
And that was the case I sent you, the last one. Now, what was the name of that case again?
The Self versus Ray.
No, the last case was Peterson versus Peterson out of Idaho.
Okay.
Okay. And Peterson versus Peterson, the judge actually tells you why that the state codes of Idaho are not law. And what he says in that case is the legislature sends the law to another agency. That agency in turn codifies the law and publishes the state code. Well, that agency does not have legislative authority. So the state codes are not law. They are only evidence of a law.
Right.
The law is actually the bill that was passed by the House, the Senate, and signed by the governor. I mean, what's the name? What's that one? I hate to pick on her, but the one that the first person and the one that stuck in my mind is the one Anna Von Reitz always pushed, and that was the one for Penhollow versus Dowens. You remember that citation floating around?
No. Once I understand, once I look at it and I realize that it's trash, that's where it goes.
Yeah. Well, it was something along the same lines that the fiction has no jurisdiction over the sovereign, blah, 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 blah. And it cites, there's two citations floating around that says that. One is Penhollow versus Dowens. That's the predominant one.
Right.
A lot of these bad citations, what happens is, and it's well-meaning people doing it.
Yeah.
They're naive
Mhm.
of the laws, and they run into someone that sounds really, really good, and they give you what appears to be source information, and you don't go read it. And they write an article about it, and you are in a situation, be it family court, be it whatever, you think they would never lie to you intentionally or intentionally or accidentally, whichever. And you copy and paste directly from the website. You never go pull the case to see if it's true.
Right.
Well, the Penhollow versus Dowens, I went to Westlaw and looked it up.
Mhm.
And a lot of these bad citations started creeping into the court cases since the proliferation of the internet.
Oh, yeah.
So people are putting in them in their briefs. The courts make a ruling. And this one judge on this one case, a guy used that quote from that was supposedly from Penhollow versus Dowens. And I actually had to proverbially pat the judge on the back. It read through his ruling, and in the footnotes, the judge said to give the guy the benefit of the doubt, he looked through every resource he had access to see if he could find where this kid got this belief. Because if he would have found it, he would have probably been more lenient on the kid because then the kid would have had a good faith reason in his understanding, right?
Right.
So I said, that was a fair judge. He actually did his due diligence instead of just disregarding what was said. But
Right.
the judge said he couldn't find it nowhere.
Right.
Now I got a Westlaw account. Do I have 100% across the board access to everything in Westlaw? No. But even if I did, I am not so naive to think that judge doesn't have access to a lot more stuff than I do.
Right. Now,
And if
let's,
go ahead.
yeah, I know you're drifting. I'm trying to keep this timely so it's not 2 hours long just to go over two cases basically.
Yeah.
So in this case, this is obviously the holding that would cover whatever you're trying to argue in whatever court. And one thing I'm going to address real quick, okay, right here where it has the Ninth Circuit 1985, if it just has the date or it doesn't even have this, it just has the volume and page number, you're going to have to question it. You're going to have to do your own research on this to figure out what circuit it's in, whether it's good law or bad law. Because if you try to apply this in the Fifth Circuit and it has no jurisdiction because there's no superior court law, which would be the United States Supreme Court, or a multi-circuit opinion supporting it as good law versus bad law, then you may be just arguing a moot point simply because you didn't go do your research to figure out what circuit this was in. So this next case, we're going to get to the next case here in a minute. Now, this case, what is the misciting or misquote of this case that's floating around in the ether of the internet that we need to address to get everybody's attention?
Okay, what's the name of that case?
This is the Rodriguez Donovan.
Oh, the Rodriguez versus Donovan?
Yeah.
That's where the guy was, where people, not just this guy, but other people, they attribute it the same as Self versus Ray, basically. It says all codes, rules, regulations are for government authorities only,
Right.
not human creators in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking due process. That's what they're saying
Okay.
the Rodriguez case says.
Which does not.
No, it does not.
Is there's
All you got to do is a
yeah,
search through the case.
yeah, there's the holding right there. This is the power of this case. This is why it was determined. That's why they issued an opinion. So this is what you should see after this right here, the citing. And if if you see anything other than this, what you would see is whatever citing is in here in the body, what you can see right here, you see where it says see Bo, I don't know how you pronounce that. I don't want to massacre it. Let me move up to a more simpler one. Califano versus Sanders. This is a United States Supreme Court. That's the U.S. volume. That's the Supreme Court volume. That's a lawyer's edition. You do not have to use a lawyer's edition. That's a whole separate series. And of course, it was determined in 1977.
Right there. Now look down the next one down. Weinberger versus Salfi.
Right.
That's where the question of constitutionality comes up right there, because I saw that last night.
Okay.
But it doesn't say that all codes are unconstitutional. It is specifically about what was being addressed in that case.
Right.
It says several cases, you scroll, okay, several cases have refused. Where'd it go? Now I gotta find it again.
Back up.
Okay. Several cases have refused to read statutory finality provisions to procedural review of constitutionality claims.
Right.
It's not saying that they're not constitutional and they don't apply a certain way. It's the case addresses specific things
Right.
dealing with this case, which happens to be dealing with one of the departments of whatever.
Right. And this says CEG, which stands for example given. And you can see this case, which is a Supreme Court case. You can see this one, which is out of the Ninth Circuit. You can see this one out of the Ninth Circuit. This one's out of the DC Circuit. This one's in the Seventh Circuit, and this one's in the DC Circuit.
Yeah, they're showing this is the normal understanding on a wide range of circuits.
Right. So if we look here, this one's from 74. The other Supreme Court case, or is that the only one? Yeah. See, it looks to me like there was nope. All these cases came afterwards, so they adopted the law of the land. This is the superior holding, and that's your example given. So that's how you read that. That's how you look at it. And that's what you have to look for. You have to go find, okay, well, here's the quote, and how have they misquoted it, miscited it, twisted it, perverted it, whatever that looks like. And I've had this happen to me. I've had Texas Attorney General's, Assistant Attorney Generals totally misquote cases. Travis County Attorney totally misciting stuff just to win. So yeah, I mean, I've experienced it, and I can send y'all to the cases, but that's neither here nor there. So we're going to get to the next case, which is the Self versus Ray.
Mm-hmm. Now, while you're pulling that up, Self versus Ray, the supposed citation is the common law is the real law, the supreme law of the land. The code, rules, regulations, policy, and statutes are not the law.
Mm-hmm.
And that's Self versus Ray, 61 WN 2D 261. And if you type that number letter combination, you will find Self versus Ray, but nowhere in that case does it have those sentences.
Right. I'm looking for the holding, because that's all that matters. That should be getting close. All right, right here. This is a writ habeas corpus, and apparently this is a death penalty case. It follows that the petition for writ habeas corpus is denied. The stay of execution is dissolved, and the respondent is directed to produce petitioner in the Superior Court for King County and the settling of the time of the execution in a manner provided by law. It is so ordered. Petition for rehearing denied. And it's a whole case. The JJ right here, that stands for justices. CJ, Chief Justice. So that's how you read all that. So as we get up here, this is a murder case. You can see right here, it's the Supreme Court of Washington, which is a state case, and en banc, which means all the justices on the court heard the case, made their opinion. And of course, this is a 63 case. And basically, that's what you're looking at. Now, in Texas, if I was in the Court of Criminal Appeals with arguing a writ of habeas corpus under Code of Criminal Procedure, Article 11071, which is argument of a death penalty case, 11.071. Y'all can go look that up. This case right here would have absolutely zero authority in Texas because it's a Washington case. Now, could I use it as supporting case law to bestow some more authority or import of my argument in my writ to the Court of Criminal Appeals? Absolutely. Or I could take this to a writ of certiorari to the United States Supreme Court after I've exhausted my state remedies. A lot of people don't do that, and they burn up that 1 year equitable tolling under the Anti-Effective Death Penalty Act, ADEPA, signed by yours truly, William Jefferson Clinton. Yeah. Hey, Chris Hauser, wink, wink. Mr. Legal expert. Because if you ain't working on your shit now, you're going to get behind the 8 ball and you're going to get left. So anyway.
And I feel, speaking of Chris, I kind of feel bad, but I kind of don't. He talked about on one of his videos about the issue with the state. And I went to his live, had a conversation with him, and I told him, I said, hey, I sent him my number privately on Zoom, and I said, give me a call. Eon wants to talk to you to help you on your matter. In other words, somebody reached out and said, look, I can help you. Yep. You know, he never reached out.
Ooh. Not going to.
That's pride. Now,
I can't say what
for those out there, to me, it's pride. If you are only going to come across that you are the expert and you are not going to accept other people that might know something that you're missing, that's pride.
Well, you know, he used a public defender.
Yeah.
So, you know, what can you say about that?
He waived his rights.
Well, he was crying jurisdiction. So apparently, his court-appointed public defender did not bring up that topic at all.
He can't.
Yeah. Oh, well, I know. I know that. You know that.
That if you want to the Westlaw, you can. 'Cause all you do is pay
Yeah,
tax
you're breaking up real bad.
is Peterson,
Can you hear me?
not France.
You're breaking up.
Is that better?
That's better.
This section in Pennsylvania, my signal gets wonky
Right. Yeah.
for a few miles. That Peterson versus Peterson case, though,
Uh-huh.
I want you to pull that up, show that on the screen, and go to page 6, right-hand side.
Peterson versus Peterson.
Yes. Now, before you go to page 6, for those that do get the opportunity to go to a law library, okay, this is what you can see. You're going to see multiple holdings on a case, but it's based on different subjects. Okay.
Jeez, I can't even
If
get
you,
it to pop up. Peterson versus Peterson.
I dropped it in your Telegram.
Oh, okay. Let me go over here. Did you send it to me directly or?
Yes. It was the third case I sent you, and I told you
Oh,
this
okay.
is the only
Oh,
case
yeah.
I have found.
All right. Reader. I'm doing an auction. That's why I keep looking to my left. Gonna open it. God, this thing is so slow. All right, Peterson versus Peterson. Okay.
Now, if you look on page 1 there, you see all the stuff under the left. You got the holding, and then you've got the numbered sections. Those are holdings also, but those are holdings based on certain subjects. So if you go to a law library, you're going to see like number 1, like, let's see, you'll see number 1 at the bottom left. It'll see appeal and error, and it'll give you the principle. And an appeal from a judgment of the district, court,
Right.
and it'll give you different holdings based on the subject.
Right.
Now,
So hang on, hang
if
on. So
if you look at,
hang on, hang on.
go ahead.
If you're in a law library, because I know you're using the Westlaw online, and I lived in a law library, so I understand what these are. These are called Westlaw key codes, and that's why you see these keys. So if you go to want to look at Texas case law, you would go to Texas Digest. If you want to go to the federal level, you'd go to the Supreme Court has a digest, and
Supreme Court reporter.
no, there's a set called the Supreme Court Digest that is nothing but the key codes. So you'd go to key codes and you'd look up the volume statutes, which is I forget what where down. It depends on how many volumes they have. Like Supreme Court Digest, it's not a very voluminous set of case law. For some reason, you would think it would be just huge. Texas Digest is very voluminous, but you would go to child custody and they're in alphabetical order and it starts volume 1. And some volumes you're going to have like volume 3A, 3B, 3C, depending on the expansion of cases held for that specific topic. So that's what these are,
Yes.
the Westlaw key codes, and this is what you look for. So if you want to know about child custody, and this pertains to you, you would go look up the child support or child custody and the actual key code is validity. So you go to the table of contents, look up validity under child custody and that volume, and it would pull up if it's a state case, it would have, I'm just going to use Texas Supreme Court, and then it have one of the 14th Court of Appeals, 1 through 14, their case law that support whatever this issue is, validity for child custody. Okay, I've explained that.
Now, yes, now back to the other two cases with the bad citations. Okay. Now you see the number 2 on page 1, second paragraph on the right. Read that paragraph. This is the only right now, basically the only case I know that actually says this. I haven't done a lot of research to find other cases, but if you read paragraph 2, it says Idaho Code is a compilation of laws enacted by the legislature. It is not a codification in the sense that the legislature has enacted the contents of the current version of the Idaho codes as the laws of Idaho. Okay. Now that doesn't really explain it. But what I want to show you is go to page 6, and it'll be the middle paragraph.
Actual page.
Starting with page 2. Yes. The actual PDF page.
5.
Right there. Right there. You passed it.
That's 5.
Okay, page 5. See that middle paragraph where it starts with the Idaho Code?
That's the Constitution. Idaho Constitution.
It's page number 6.
Okay. Yeah, that's why I can't find it. Right here? Yep.
Yep.
You want me to read it? Yeah, you're breaking up again. Getting Pennsylvania. You're breaking up. Can't hear a word you're saying. Oh, actually lost you. So he's got to jump back on. Anyway, I'm going to read it. The Idaho Code is a compilation of laws enacted by the legislature. It is not a codification in the sense that the legislature has enacted the contents of the current version of the Idaho Code as laws of Idaho. Quote, the present Idaho Code is a compilation of laws, evidentiary, but not a codification thereof. And then here's the case law. It brings it up, and I'm going to presume this is their highest state court. You're back with us.
Yes, I had to do a self reset.
Yeah,
so if you read on through that, can you hear me now?
Yeah.
So if you read on, he goes on to say that compilation is evidence of the laws. You see the 4th line on it.
Yeah, you're still breaking up. You're breaking up.
Okay. Can you hear me now?
Yes, I can.
If you look at the 4th line in the next paragraph, it says the Code Commission, that's who created the code,
right,
has no legislative authority. This is the only case I'm aware of yet
lost you again. So anyway, while we're waiting him to come through, my first question is,
Okay.
what is the Code Commission? So we have to go over here. In 1947, the legislature, Idaho legislature, created the 1947 Idaho Code Commission to consist of 3 members of the Idaho State Bar who were not holders of any public office or position, were actively engaged in the practice of law, and were to be appointed by the governor from a list of 7 qualified persons whose names were submitted by the Board of Commissioners of the State Bar. So that's where that came from, and that's what the commission is. So the commission's not even the representatives of the voters. They're just appointed by the governor, and they're just attorneys. So that's what the commission code is. That's why they really, the code commission has no legislative authority. Duh, they're not voted in. They're appointees. The code commission complied with section 5 of the Senate bill. So yeah, this just gets into some more minutia of it. So we've lost Pastor. He's in a bad spot. So without having him popping in and out, I think I've pretty much covered everything that we need to discuss with this particular video. And basically what we're talking about is bad sightings, bad case law, how to go look it up yourself. Just do a simple Google search. And once you do it, you can vet what you're actually trying to argue and make sure that it has jurisdictional authority applicable to the jurisdiction that you're litigating in, whatever that looks like. Because a lot of people, you'll go find something on the internet. You might even go to an actual appellate case and an opinion, and it'll be cited in there, but the original filer miscited it, and the court just has it in the record because they're showing that somebody filed this. In no way, shape, or form does that give it any validity. Just because that I could create a amicus brief and submit it into any United States Supreme Court case, which is a friend of the court brief, and cite anything I wanted into it. And if they incorporate that into the actual publication of their case, then it's going to be in there, but it's going to be totally incorrect. And that happens more than we would desire it to. Can you hear us? Are you good?
Yeah. Stop.
Yeah, you're still breaking up. I'm going to go ahead and wrap this video up, and we'll get into another one. I'll call you offline to get with you and figure out what we're going to do next. So thank you, Pastor, for coming on and being with us. Thank you, everybody, for watching this video. I hope you learned something, got educated. Fearless Floyd Show on Telegram, Yahoo, Rumble, and YouTube. FearlessFloydShow.com. You can email me if you want, fearlessfloydshow@yahoo.com. Like the video, subscribe if you want to see more content like this. Hit the notification bell when I put out new videos, and share this video with God and everybody, because God bless you all. Y'all need to understand and comprehend and be able to do your own research when it comes to these legal sightings to make sure you are doing it correctly and not incorrectly. So when it gets submitted into whatever court you're trying to deal with, they're not going to laugh you right out of the court and take it and dump it right in the trash can because you just cited a whole bunch of gobbledygook garbage that has no authority. So with that, thank you, kids. I appreciate you all watching the videos. I'm gonna have to reshoot the videos that I shot earlier because I didn't do a microphone checker. That's where we're at. Thanks, kids. Appreciate you. And I'll see you on the next one.